My lord, item number 6, my lord. We have filed an additional affidavit yesterday, my lord. That may kindly be called. Item 6.
Yes.
We have filed an additional affidavit, my lord, in item number 6. That may kindly be called. 6. Okay.
Item number 16, Lordship. I am newly engaged. Short adjournment, Lordship.
Why is that come up for order? You were to impeach somebody. Isn't it?
Otherwise, proceedings are complete.
Yeah, this matter, if I remember, in matter where a person concerned have become junior.
Yes.
In MSc.
Not Pakistan.
Where? What is the matter about?
It's a challenge to a draft retention list, wherein both parties were selected in a different selection process. The parties which were selected in the earlier selection process were placed at a junior in the final retention list. Therefore, we raised objection. Therefore, our objection was also not considered. Now, the minutes of meeting says that our marks in the Viva were reduced.
From LTA. LTA to UTA.
Yes, sir.
Now what is come up for orders? If you are not prepared the orders,
No, sorry, Lordship. Okay, Lordship, I'll be with.
just come up for orders. We'll look into it.
Okay.
Don't mention
Yes,
order matters.
Supplementary item 15 fixed at 2 p.m. for admission.
After some time, matter will be taken. But it will coming shortly.
You got the record? Yes, Mr. Kohota. Record.
Lordship, I have received certain instructions, Lordship.
Is the only record?
Lordship, otherwise the whole record is, Lordship, received by the police, Lordship, in connection with that particular case. My lord, may kindly peruse the instruction first page, Lordship. And Lordship, the license was also cancelled, Lordship.
Huh?
License was cancelled, Lordship.
I think that we cancel.
Cancelled. Last week. And he has filed a reply on, Lordship, 29/3/25 against the proposed cancellation of license, Lordship. My lord, may kindly peruse first page of the instruction, first page, Lordship. If Lordship permit, I can read it, Lordship.
No, nothing remains then.
No.
Mr. You have to challenge this order then.
I have submitted reply on 4th December 24, and interim order was issued on 27 January, and my license was cancelled on my lord 2nd August. That is during the operation of the interim order, my lord. This action has been taken. Which amount, my lord, contempt of court is, my lord, because court order is there not to take any coercive action against me, my lord.
Coercive action means, what do you mean by coercive? You have not put that aspect out there. Not to take coercive, not to take any action pursuant to a proposed notice.
My lord, court order is there.
No.
My lord, matter may be taken after some time, my lord. Arguing counsel of this is Kian Sudhir sir will appear, my lord, after some time.
You cannot on the basis thereof get it.
After some time, my lord, maybe. You will come.
Isn't it known that I will take up the matter at 2 o'clock?
My lord, my lord.
And if your senior is not available,
Coming soon, my lord.
number 2 comes. Where is that?
Coming soon.
Don't put. I'll put. Senior, no agent. Where you are putting this? No adjournment on senior.
I'm not saying that for time being, my lord.
No time being.
during the operation of the interim order, whether it is permissible to the respondent number 4 to take action against or not. In this regard, my lord, I am to submit one Supreme Court judgment.
You have only asked for interim order for stay of the suspension. Yes, Mr. Mr. Chaudhary, they have, in pursuance to the order passed, in pursuance to your reply, they have cancelled your license.
Yes.
So therefore, the question would be you need to challenge that order. Look, that is the only course of action. Whether it was done, no coercive measures would mean that, taking into account that no coercive measures has to be taken in the context of paragraph number 20 of your writ petition, wherein you ask for suspension to be stayed. So it has to be taken from that context. But anyway, you can very well develop your case by filing a fresh writ petition challenging that order of cancellation. I think that is the best way.
In any case, we have to otherwise either way amend the writ petition or I file.
I think
Later, my lord, the lordship will give me liberty. I'll consolidate everything in the new petition.
Huh?
Lordship will give us liberty to challenge this because
no, I'm saying now you see the question of suspension no longer remains, taking into account they have
no,
cancelled your license.
my lord, even the suspension aspect should be kept open. I'll challenge because there are
No, you challenge it, but the fact is when if a person is dismissed and
naturally.
the suspension does not remain any further. But anyway, I keep a liberty, I'm
Yes.
giving it to you. Appearing on behalf of the petitioner. Mr. K. Gogoi, the learned counsel appears on behalf of the respondent. number
1 to 4.
3.
Technically,
1 to 4.
1 to 4. And Ms. So-and-so appears on behalf of the respondent number 5. 5. 5. 5. 7. The petitioner in the instant with petition have challenged the continuation of the suspension order dated 10/7/2023 beyond the period of 90 days, which as per the petitioner would not have been would not be permitted, that is not permissible in view of clause 15(2) of the Assam Public of Articles Order 1982, read with the Control Order of 2015. It is further seen that the petitioner, that in the meantime, the petitioner was issued the show cause notice, which the petitioner claims that it was received by the petitioner only on 27/11/2024. And thereupon, the petitioner had submitted a reply thereto. It is further seen, in pursuant to the order dated 4/8/2025, Mr. K. Gogoi, appearing on behalf of the respondent submits that in the meantime, on 2/8/2025, the petitioner license had been cancelled by an order passed by the district magistrate or Peta. You've given a copy of the order
Yes,
to him. A copy of the order has been furnished to Mr. A.K. Azad, the learned counsel, assisting Mr. K.N. Chaudhary, the learned senior counsel. So Mr. K.N. Chaudhary, the learned senior counsel, submits that he would not like to press the instant petition in view of the said development and would like to file a fresh petition challenging the order dated 2023 and further keeping all the contentions raised in the instant writ petition open. Full stop. Mr. Chaudhary, I've said that keeping all the contention made in a writ petition
open.
taking into account the said submission, a copy of the order dated 2/8/2025 so produced before, so by which the petitioner's license was cancelled is kept on record and marked with the letter X. This is your record, no? Or can I keep
My
it?
lord, may kindly keep it. Plus,
So the record, the records which have been placed before this court during the course of the hearing is kept on record and marked the letter X. Full stop. The counsel appearing on behalf of the petitioner would be at liberty to take photocopies, would be at liberty to take, you have a copy now?
I'll handle the so I can.
Would also be furnished with the records which have been produced before this court. No, the counsel appearing on behalf of the respondent shall also furnish copies of the entire records which have been produced and kept on record and marked with the letter X.
That's
So,
fine.
in that view of the matter, the instant writ petition therefore stands closed on withdrawal. Liberty is given to the petitioner to assail the order dated 2/8/2025. So, this court further observed that the issues which have been raised in the instant writ petition is left open.
Plus.
Deep.
If they model, if any, stands.
Deep.
Daily list item 13 fixed at 2 p.m.
What is this?
My lordship, I have challenged it page 121, my lordship, whereby petitioner was, my lordship, two punishments were imposed upon the petitioner. Page 123 is the relevant
Punishment done on whom?
upon the petitioner who was working as the miscase assistant and executive assistant
What ground?
on ground that, my lordship, that he has gross misconduct while dealing with a file in which an execution case there was a stay. My lordship might remember this case in which a petitioner while was working as miscase assistant and execution assistant. At that point of time, when my lordship, may I go to the little bit of facts, my lordship?
Please,
My lord, what happened was the one person, one Makhan Chandra Paul of Silchar, he has, as plaintiff has filed a title suit for ejectment against 11 defendants. In the meantime, it went ex parte. Ex parte judgment and decree was passed. In between 40 execution of that ex parte judgment and decree, one execution case was filed. In the execution case, writ was issued. In the meantime, the judgment debtor, they approached the Honorable High Court in which by filing a civil revision. In the civil revision, they got a stay. So on the basis of that stay, execution was also sought. In between, after the civil revision petition was dismissed by this Honorable Court, then the decree holder has filed a petition for execution of the writ once again. As such, the writ was executed and the Nazir was directed to report on the same. In the meantime, the judgment debtor has filed a petition for stay of the execution before the same court by filing another miscase, in which the Honorable Court, without calling the record, and without providing anything has drafted a stay to the execution in that miscase.
By this court,
No, my
by that court.
that. So
And then the execution was carried out.
already proceeded, and when the report was called for, the execution was already proceeded. Then thereafter, my lord, SOCOS was issued to the petitioner as well as the dealing assistant by the court that when a stay order was there, then why the writ was executed by the same court who has given the stay order as well as the order of execution. The issue was here in this case was that the Honorable Court at Qatar, Munsif Court, has not provided the details, only has granted stay of the execution. And while dealing with that, has not called for the record. Has not, and the advocate on behalf of the judgment debtor has also not informed about the stay of the execution about the miscase. So in between, the execution was done as on the basis of that writ. And as such, the complaint has been filed that in spite of this stay, the execution was done. And as such, the Honorable Court, as such, the direction was granted to the inquiry officer who was the additional citizen to do a detailed inquiry. And on the basis of that inquiry, my lordship, the petitioner who was the miscase assistant and execution assistant was
The punishment given?
he was imposed, my lordship, two punishment. He was imposed two punishment. One was reduction to lower time scale of pay from basic pay for a period of 3 years. And along with it, the petitioner would not earn any increment of pay during his.
It's the one and the same.
Yes, my lordship. Two punishment, one major, one minor. And both the punishment were blended together simultaneously under one head, my lord.
So there is reduction in rank
Reduction in rank
and
times one was, my lordship, times lower time scale of pay, and I would not earn any increment.
Huh?
The petitioner would not earn any increment of pay during his period. Two punishment, my lord. One was major, one was minor.
so what is your case?
And
here?
my case is that, my lordship, my case was that in this case, the petitioner was not entitled. My lordship has, on last, my lordship, if,
I asked you to produce the record.
yes, my lordship.
We'll take it up as the last item today.
Supplementary item 14 for motion.
Yes, what it is.
Yes.
Very,
This is picture matter.
what has happened?
Page 12 is the tender notice. It was issued on 4/6/2025, where the petitioner has participated and he was a valid tenderer and he was the third highest bidder.
Where is Mr. P. Sharma? Huh? I know that. Where is he? This is in terms with the order of 17 or 10/7/2008, 2025. Pursuant to that Titeli Prasad judgment, na? Bhakti judgment of the Supreme Court, wherein it says that you have to. Yes, Mr. Sharma. Here is a case where now this court has to search the advocate. This is the stage.
No, Lordship, my name is not there. I have not provided copy also, I think.
Okay. Now here he is challenging the issuance of a fresh tender.
Yes, without assigning.
We dispose it of as per what I have done.
Yes.
Your fresh tender also does not include, doesn't seem to include. Have a look, give it to him, copy.
He knows it.
Fresh tender also does not include, does it? Yes.
This should also come after that Supreme Court.
Same order. Enough to repair the. Same order.
The
I'm-
same order.
What am I doing is 4/6, I'm setting it aside because you see the Supreme Court judgment is of 21/2025, wherein the tender document had to include that clause
Lordship.
and there is subsequently an order passed on 10/7/2025. So therefore, I'm setting aside the earlier NIT and the second NIT also, which is being issued, which is on 22/7 is also being set aside. And they will be at liberty to carry out. That same order. which
Same
I
order,
passed
same order.
That day.
Yeah, yes,
another
Lordship.
matter. It was Silverwood, I think. What is the name of that case? It happened 2 days before, no?
Yes, Lordship. Yes,
Wednesday.
Yes, I will give it, Lordship.
Wednesday, I passed the
Yes,
order.
Lordship.
Some Titelia. What is the name of the judgment of the Supreme Court? Titelia.
Teliguri. Copy, dear Lordship.
I have quoted this
Yes,
office order. It was a silo, huh? I think Pradeep must have taken it. Okay, this was,
Yeah, we have fresh tender.
really good. For following the mandate of.
For admission, item 1, daily list, part heard.
Will also take some time. We'll have it at the last but one item. Thereafter, I'll have. Today. This item will take some time. Today.
4 o'clock, I have another one bench will sitting in.
Huh?
Honorable Justice, I have a matter in 4 o'clock. I brought
Before,
Justice Surana, Honorable Justice Surana, single bench.
don't worry. Before 4 o'clock, the judgment will be delivered. In front of you. Because both of you have not placed the recent judgment of the. I take the pain of looking in.
After Sorok Jadab,
2022 12 404. Look into that. Judgment.
Item 2,
Yes, what is this? PDCL.
Yes, last order, Lordship. The representative of the,
We have paid the compensation.
my lord, the process has been initiated, my lord. These instructions, my lord, petitioners were informed about their right under the relevant rules. Page 1 is the letter addressed to the petitioner as well as the district authorities, my lord. Fine.
No, when you have HT poll, this will come under the Telegraph Act.
This
Isn't it?
is under the Assam Electric Works of Licensee rules, my lord, flowing from the Electricity Act 2019. Page 2 onwards is the other rules, my lord.
Now, who is going to
The DC, my lord, is dealing with the matter. Page 8 of the instructions, my lord. The first hearing has already taken place,
so there will be some time required.
my lords. My lords may, subject to what lordship holds, my lords may dispose of the writ petition with a direction to the DC to carry out the assessment. Let it be pending, lord. Within a specified time frame, my lords.
No,
Let it be
when
pending.
they have approached us, we should do something. 2017, after pending out there, then asking them to do it, no. As you are initiating the process,
Yes.
you finish the process within 2 months and give us an update.
Very well, lord. No, they are supposed to,
The petitioner herein heard the friends of the learned counsel appearing on behalf of the petitioner and the shortly appearing on behalf of the respondent.
2 and 3, my lord.
The not you are appearing for 5 and 5 and somebody appears for 6. 1 and 6, no? The petitioners herein are aggrieved by the action on the part of the respondent authority in erecting ST electric posts within their private land. Full stop. The fact that the ST electric posts are erected within the private land of the petitioner are not disputed. Full stop. The question, however, arises as to what compensation the petitioner would be entitled to. It is seen that by an order dated 24/6/2025, this court, taking into account the submissions so made by the episticial learned counsel for the episticial, that a month's time is required to enable the respondent to initiate the process for payment of compensation to the petitioner. This court, the learned standing counsel of the episticial submits that in that regard, process have been initiated in terms with the Assam Electricity Works of Licenses
Licensees.
rules, licenses rules 2019, which are rules made under Section 67 of the Electricity Act 2003. The learned standing counsel of the episticial submits that some more time would be required for the purpose of assessing the compensation and thereupon payment. Considering the above, this matter again on 15th of October 2025. In the meantime, the respondent shall do the needful for carrying out the assessment, as well as all the respondents, including the respondent number 6, shall do the needful for carrying out the assessment and payment of the petitioner and provide an update to the petitioner. This court. This direction is being passed taking into account that the instant writ petition is of the year 2017 and almost a decade old. We have already done the work and you have not paid. In their land you have put it, you have not paid any amount.
No compensation. Matlab, I must fairly submit. No compensation.
So remove those both.
Matlab,
You
this
should
is,
remove-
these are,
No.
there is
No,
not a-
we
it is not
should
a
not give
single
such a long-
electrical poll, my lord.
No. I think this is a fit case where we should ask you to remove those.
My lord will consider,
No.
this is not a single poll. There, it is a 33 kV.
Whatever poles are going through his land, as you have not paid the compensation,
Now,
it is a
madam-
violation of Article 300 of the Constitution. So we therefore ask you to dismantle the. No, you have not made the. You dismantle the.
My lords, the compensation will be
Please
paid.
don't
My lord.
go
That
on
is,
like this.
no, the compensation will be
Well,
paid. my
is
lord.
law for APDSL? There is no law.
My lord,
I'm asking you whether there is any rule of law for APDCL
certainly,
or they can do anything.
no, certainly, my lord. there-
How will you feel if it is done in your house? You like it? Would the chairman of the APDCL like it? And if it is done in his house, he will be the first one to complain. These are the persons who have been fighting out here for out here. I do going to it too.
My lords may make it
Itu-
1
itu
month,
jo.
my lords.
Dos
My lord-
September.
My lords,
Showing it as part of 10
Good.
September update.
Yes.
How much? And ask for everybody to do it. You cannot do like otherwise remove those.
keep it.
You want to remove the poles or you want a contract for removing the poles? Then which one do you want? No, you have nothing to say. You have done the work, it's okay. I'm not concerned with that. They have given you a contract and you have done the work out there. I understand that. Now, if Mr. Nath, you want that there should be a direction that I should ask the APDCL to give you a contract for removing the poles, you make a submit. Otherwise,
Deeply, my lord.
next.
Yes, I'll be reply of the affidavit, my lord. I'll be the phone number type.
This is the accountant business, no? That I fixed it when 2020. Wait, huh? Huh? Because here I think, but that is not going to happen anywhere. I think we need an authority pronouncement here, saying that they are, because what
Yes,
is
ma'am.
happening out here, they have all along considered it to
In
be.
fact, your lordship's last order is quite elaborate. Lordship's last order, lordship's recorded everything. Yes, my lord.
Very long.
So that order, my lord, gives a clear picture. And perhaps my lord, there is requirement of
Case of the private respondent also made a request that the private was actually appointed as PTA. Frequently promoted because of the fact that these people were promoted to the post of an accountant, although they should have been promoted to the post of UTA.
Yes.
That does not take away the right of being considered for promotion to the post of
their promotion, in fact, to the post of accountant is absolutely symbolic. It has got that lordship has recorded. That is also my, my lord, in my opinion also. To the accountants.
But
Because they didn't have any choice.
you have no case. You are the person who is enjoying the post of head is. What is that? That rules there is nothing. Isn't- Now, if the rules are not there has to be a judicial pronouncement. Then with the creation of those posts, huh? Mr. Sharma, you were an LDA. You were an LDA. You were initially an LDA, promoted as UDA, and then being promoted to head assistant. Their cases, they were also an LDA. Now, in these three districts, 3 posts of accountants were brought in. The district judges, what they did, they equated the post of accountant, in as there is no rules to that effect, equated taking into account the pay scale, equated them along as UDA, and these particular the petitioner or the respondent, the concerned respondent in the other matter, have been also discharging the functions of the UDA, although they have been appointed as accountant. And thereupon, in one case, one of the CGMs have not allowed, but the other person have, the district judge have allowed, or whatever may be, it is, or vice versa. So this is what has happened. No, no, whether you are senior to him. No, no, his post was not taken. Nah.
Lordship, but
He being an
participated,
accountant,
he participated, he failed and then he came, but he has
I
in
was
the,
not allowed to participate.
but he, in the writ petition, he has not
allowed-
challenged anything, Lordship.
He has not gone
Lordship,
for the record.
let me complain, Lordship, in the writ
which
petition, Lordship.
matter
Next,
date?
maybe I have
Joint
not
of Bora,
participated,
7112.
not participated.
7 of, yes, what is it?
Lordship, first of all, Lordship, the petitioner is an accountant, Lordship. And in my considered view, he's not eligible for a head assistant because he is not in the upper UDA. He is not in the UDA.
That I'll take care of.
But because as per 6.1 of the, that is 1987 rules.
That I'll take care of.
That here, Lordship, original advertisement is Annexure 4, Lordship,
Of his writ petition.
of this writ petition, Lordship.
Yes.
Here, Lordship, the initial advertisement required 10 years of experience as UDA. 10 years experience,
You're referring to page 28?
Lordship, annex.
5 years, well, it is relaxed.
Yes, Lordship. Annexure, Lordship, just a minute. Annexure 4, Lordship.
Page 28? Is it page 28?
Yes, Lord. Yes, yes.
What does it say?
And no, not advertisement, Lord. I am wrong, Lord. 20, it is wrong, Lord. 29, Lord.
Yes, what is?
Lordship, here, here advertisement is there, Lordship. Applications are invited from the eligible employee of the establishment of CGM for filling up the following vacant posts in the office of the CGM. Udalguri. Head assistant, 1 unreserved. The candidates must have experience as UTA with at least 10 years of service as such to their credit, including supervisory assistance in any judicial measure establishment of Assam as on 27/2/2023, Lordship. My contention is that, Lordship, this advertisement was never been challenged by the petitioner, Lord, in this petition, Lordship.
Then?
Then, Lordship, initial, then, Lordship, annexure. Then again, 31, page number 31, Lordship. Page number 31, Lordship. Here, Lordship, application are invited from the eligible employee of the establishment of CGM for filling up the following vacant post in office of the CGM Udalguri. Here, Lordship, eligibility criteria is being reduced. Candidates must have experience as UDA with at least 5 years of service as such to their credit, including the supervisory assistance in any judicial measure establishment of Assam as on 16/9/2023. This was also not being challenged in the writ petition, Lordship.
Now, he is
The Lordship,
seeking a cancellation of your appointment
Lordship,
pursuant to which advertisement?
pursuant to 31, page number 31.
So why are you asking for 29?
29, that he has not challenged it. I'm not asking, Lordship.
I'm not on that. That has no relevance. You're only concerned with 31.
Lordship,
Yes. So here, your therefore submission is 31 has not been challenged.
not been.
Then
Then, Lordship, here, Lordship, the whole process, my appointment was, I think, because this was not been challenged, and this criteria I fulfill, Lordship. So
I will hold it that UDA and accountant is one and the same. Then you need not
but
make-
it is not in the this what is called this service rule, Lordship. The existing service rule, this
service rules is awaiting.
not service rule, you waiting. That's true, Lordship.
Okay.
Then this order, this
And the
notification.
High Court has not filed an affidavit. He is right under Article 14 to be considered for promotion. It's a fundamental right.
But here, Lordship, this judicial department, Assam judicial measure establishment service rules, this executive order rules, this is being followed nowadays.
Which one?
This government of Assam, this in the this judicial measure establishment ministerial service rules, Lordship.
1987.
Lordship. That is page number 62, Lordship, my affidavit, Lord. My recruitment was on this base of this 6-1 lot.
Hmm?
This 6-1,
Very big.
this page 62,
Page
page 62, if I'm not wrong.
62 does not show anything.
Head assistant.
Service only, it says upper division, lower division.
Here,
Then-
Lordship, no, the recruitment part, Lordship. 6, recruitment to the service shall be made by the appointing authority according to the procedure laid down below. Head assistant by selection
I
from the,
don't have anything to that effect. Oh, page 61. Type of page you have put out there.
here, Lordship.
Page 61 is the other side. Anyway, head assistant from upper division system with 10 years of service as such to their credit.
Including supervisory assistance.
Then
in-
how did they make it 5 years?
This is by relaxing rule 17.
Who relaxed?
Huh?
Who relaxed?
It's CGM lot.
Huh?
CGM lot. Rule 7.
CM. Mr. Das, is it possible? Now, are you therefore saying that there is no eligible employees in the entire state judiciary of Assam? No, I see page 31. Did they consider in the resolution that there was nobody? You have a resolution. Sixty. This is only a notification then. Where did you publish this notification? It has been given in all. It- Yes.
Thereafter, another minutes in
So where is the notification?
page 71 is the subsequent minutes.
No. Minutes cannot be there.
Huh.
Where is the notification?
By which
You are relaxing. It is only a minute.
Yes, my lord.
A minute exercise by 3 persons. Who is the appointing authority? The Chief Judicial Minister.
Yes,
There are other 2 persons also there. In terms of Rule 17, who can do it?
appointing authority.
Who is the appointing authority?
Here, CJM, my lord.
Where is he? He has not done it.
No, if your lordship
It is a
kindly,
combined effort of 3 persons. Whether
m-
it would be permissible.
page 71, if your lordship kindly take up.
I've seen it.
Accordingly, selection board by resolution that is resolved to relax.
Whether the selection board can do it. My question therefore is, can the selection board do it or the appointing authority do it?
But it has to be by the appointing authority.
No.
my lord.
Not done.
No,
Without
see-
relaxation, this
see-
is being done.
Chief Judicial Magistrate was a
So we do
member.
one thing. We set aside your appointment on that day. Forget about that.
After the
And,
reservation,
and ask them not to do anything till the rules come. No, without relaxation, it is in violation.
maybe that's the record.
Records have been called, records have nothing. Even the High Court is not in a position to file an affidavit. Isn't it, Mr. Das?
No.
High Court is embarrassed to file an affidavit. High Court is embarrassed to file an affidavit. That's why they have not exercised 235 till now in respect to these type of matters where it is required, taking into account that the state government is keeping silent.
Lord, one additional information, perhaps Lordship is aware. Lord, after the last 2 discussions before your Lordship, Lord, I brought this issue before the Registrar General, and perhaps the Registrar General, so far my knowledge goes, the Registrar General has placed this before the rulemaking committee for the purpose of issuance of any notification or clarification by this Honorable Court, my Lord. That was my
Where
instruction.
the High Court has to take care of its employee,
Absolutely.
of the employee of the district judiciary.
Absolutely.
It cannot be doing in such manner. In fact, if they file an affidavit to the effect that the accountant also means the UDA, solves the problem. High Court is not doing it, sleeping.
In rulemaking, in the presence of the rulemaking committee, my lord, perhaps it will not be conducive on the part of the RG to file an affidavit to that effect, my lord. Since rulemaking committee is already there, it has been placed, I am told, it has been placed before the rulemaking committee, I think, my lord. This issue flagged before the committee.
See, the decision has to be taken not by the rulemaking committee. The decision has to be taken by the full court.
Yes. Earlier,
When the exercise of jurisdiction is under 235, it is
Yes.
not the Chief Justice.
is the full,
It is the full court.
earlier equivalence of copies, typists and
On the
computer typists.
administrative side, I have never seen anything to place to that effect.
Okay. May I just cross check once with the registry, my lord?
So all are represented. Help us, sir. KB. That we have. You should also be you should also take it up. What?
এটা আগামী আগামী 28 মেটারটা আগামীটা নট এটা এটা রিলেটিং টু অ্যামেন্ডমেন্ট অফ রুট 2008 yeah my lord, one simple thing my lord, LD is promoted to UD to head it and then to up to Chefsada, but another LD is promoted to accountant, so if it's not promoted then it will be in there.
No, it is the fault.
Not be rule, but equality before the law and equal protection before the law.
And you were appointed later on. You are junior to him, na? You were junior as LDA to him. Because of the fact that you see the gradation list.
Junior, page 33.
Page?
Page 33 of the report.
Yes, what is the name of the petitioner? Huh? Name of the petitioner is Joanto Bora. Huh? Accountant. And your name is?
Ananda Pramod.
He retired part. Pramod retired. It was only state target.
That. Tell
Yes, my
me
lord.
one thing. How both of their date of termination is same? Can you
Maybe
come to page
because of
33?
age, my lord, perhaps.
No, can you see? Date of birth of
68.
the private respondent is 1368. And the accountant, the petitioner is 28/2/1968.
Yes.
If he's 28/2/1968, his retirement would be obviously on 28/2/2028. There's no quarrel.
Perhaps FR
But as
56.
regards 1368,
FR 56, my lord.
so then it will be 28/2. Last day.
1 day prior, my lord. It will be, if the first day of the month, then the last day will be the date of retirement.
Last day of the earlier month or
Earlier
the
month.
next?
Earlier month.
But he was otherwise senior in LDA.
He was otherwise seniorly LNDA, but UDA, the game changed. In fact, my lord, seniority is not in, I think, seniority, although, my lord, at one point of time, respondent was senior, at UDA, the petitioner becomes senior. But I think this issue has to be clarified, my lord, by your lordship. Because, and
That is why
this-
I'm
this-
thinking of making it stable.
and one more thing, my lord, this will be only for these 3 districts. It doesn't have, because other districts doesn't have the post of accountant. So it will be confined only to the 3.
Because if the rules also come in,
Only issue, my lord, perhaps.
no, why I'm saying that
Yes.
if the rules also come in,
Yes.
it would not help anything here. Because the rules have to be applied prospectively.
Exactly.
So the rules would not have an impact on this proceeding. So I have to dispose it of.
Yes. That hurdle is already there, my lord.
So I do the same.
Fine.
I don't have TV. So your only contention is, as per the rules, 6, it is only a UDA can become. But the question is, here they have used the term UDA or accountant or the officials, the department. High Court has not given any clarification on the administrative side. Because I don't want that. Because if it's done, again there would be a problem.
Again, there will be a notification, then prospective or
That would
retrospective.
again be prospective. So therefore, the High Court has not given anything to that effect. So therefore, it has to be decided in the present facts. as to whether they were treated in the capacity of a UDA or not. If they were just filling up the post, although a additional post is being created, that post is being created and it has been filled up because it is the same job of an UDA the accountant is doing. No, the petitioner has not challenged it, the advertisement, only for the reason that it is a deemed UDA. And as such, not necessary, because all along it is being treated. And as such, in when the district judge also treats it. In Mr. A. Bhattacharya's case, the district judge treats the UDA and accountant similar of the same district. But in the chief judicial magistrate, he does not. Can't help it.
In fact-
Therefore, this court had to pass the order to that effect as to whether it was actually to that effect or not. It will be only in the present facts.
In fact, the advertisement also says UDA.
Hmm.
It doesn't say accountant.
No.
The decision came by virtue of this minute that I have shown, page 71 and 69, to exclude the accountant.
Let
So,
me give
and your lordship's decision will be purely on the basis of the peculiar facts of the case, because it will not have
on the
effect pan
peculiar
assam.
facts of the case. Whether there is a challenge being made to the thing, I'll obviously consider Mr. P. Sharma's case.
Correct, ma'am.
Now the question is whether should I go into the question without there being a challenge as to whether accountants should be equated without a prayer to that, or if in the writ petition it is already there, then the prayer would not make a sense to
Yes.
that effect.
Pleadings are
So
there,
these
then it's
things I will
sufficient.
look into it. Hearing complete, judgment reserved. Enough. Too much. Hearing complete, judgment reserved.
Look, one aspect I just flagged, my lord. He has already been promoted to head assistant. In the event of, my lord, any interference, then he'll be brought down, and again the person who is holding the UDA post, he will be again brought down.
There will be obviously one post vacant because now whatever may be, it was made subject to the outcome.
Yes, yes, true. Correct.
When it is being made subject to the outcome,
It will be
obviously,
outcome.
this will
Yes, yes, I understand.
Item 5,
and one post will be obviously there vacant. Taking into account the other person will obviously go
Yes,
up.
yes. It will be just, my lord, clipping.
Yes, Mr. Nath, what is your case? Non-payment.
My lord, not loan payment, my
What is it?
not running a market, man. And there is, my lord, another illegal market.
Illegal private
A
market.
private
what do you
market
think?
started.
And how the state. Oh, go to the civil court. Who is running the market?
That is from 30th.
You have not filed affidavit?
Your lordship,
When?
only one week time may be allowed, your lordship,
One
with the concept.
You? R.P. Bora as well as Mr. A. Begum. 6. One final opportunity to file their affidavit position. This court duty takes note of that on the earlier occasion that duty takes note of that notice was issued by this court on 26/3/2025, and almost 4 months have elapsed. In that view of the matter, this court fixes the matter on 10th of September 2025. The respondents are given the final opportunity to file their affidavit by 29th of August 2025. The petitioner, if so advised, would be at liberty to file the reply on or before 8th of September 2025. It is observed that if the respondents do not file their affidavits, this court shall dispose of the petition on the basis of the materials already available on record. Mr. Mahanta, have a look. What is this?
May it please the court. But matter pertains to non-payment of contractual bills. Sir. Today they have filed the affidavit. Respondent number
On payment of
contractual bill.
what is the affidavit?
Rejection of salary. But, salary rejection.
What is this? What is it? So let him provide the GST.
My lord, we have already, yesterday we have filed our affidavit, additional affidavit, my lord. We have brought into record, my lord. That's clear. Additional affidavit, my lord, page 45.
Hmm?
Today it was called for, my lord. Annexed to page 45 of additional affidavit.
Now what is here? How much you are claiming?
Well, near about 17 lakhs, my lord. 16 lakh 82,411.
But our admission has been there 42,000.
But if they may verify and if my claim is genuine, my lord, they may pay, dispose it of.
Did you do?
Yes.
You have filed an affidavit, huh?
Yes, Your Lordship. Stay on the Lord.
Page? You're referring to which page?
My is not on record, Your Lord.
Not on record.
Not on record, Your Lord. Just before some time I have filed.
When?
Cannot, for 1 hour.
It has been submitted by Ms. Arteta, the learned counsel appearing on behalf of the water resource. That an affidavit has been filed, however, the said affidavit is not on record. This matter on 27th of August 2025. The registry that seeks record the same.
Item 7.
Same petition here, my lord.
Seven Lordship, same issue. I have the instruction, Lordship. Amount of sanction, they have claimed, Lordship, 34,65,881, Lordship. And as per official communications, they will get 35 lakh, more than their claim. That's why I sought from justification, Lordship, then they've said it. Last pay, due to the GST not clearance, Lordship, that was rejected.
Have you updated the GST?
Well, updated, my lord. In the previous case, I have,
Here?
here we will file our affidavit.
Huh?
Additional. We will file our additional affidavit to bring it on record.
It was done when?
What? On
6/8.
Lordship. Amount was sanctioned on 26/2025. Accordingly, that was placed before a treasury and treasury rejected it due to the
How much is the amount here?
amount is Lordship. They are entitled for 35,86,780, although their claim is 34 lakh. And earlier occasion Lordship 6,71,788 already paid Lordship. Now they are entitled 29,68,992. That was sanctioned. Accordingly, it was sent to Treasury. Treasury rejected on the ground that Lordship GST was not applicable. Otherwise,
Heard Mr. E. Chaudhary, the learned counsel appearing on behalf of the petitioner. The case Gogoi appears on behalf of the
respondent.
authority. The petitioner has approached this court challenging the actions of the respondent authority in not clearing the outstanding bill to the tune of rupees 34,65,881. Today, Mr. A. Gogoi, appearing on behalf of the respondents, have placed before this court an instruction issued by the Administrative Officer, Assam Administrative Staff College, which is kept on record and marked with the letter X. From the document which has been kept on record and marked with the letter X, it seems that the total amount to which the petitioner is entitled to, as per the respondent, is rupees 35,86,780. So out of the said amount, an amount of rupees 6,17,788 have been paid on 29/4/2025 to ECS. However, the amount of rupees 29,68,992 could not be paid, and was rejected by the dispute treasury on the ground of non-compliance of the GST by the petitioner. And it is also stated that the petitioner was duly informed by various letters. However, the petitioner have not updated their GST payment till date. So, taking into account the above, Mr. A. Chaudhary, the learned counsel appearing on behalf of the petitioner, seeks some accommodation to obtain instruction and to file an additional affidavit.
Apply.
List the matter again on how much time? 27?
27. Apply.
Item 8.
Yes, Mr. Nath.
But my clarification of the EC is that they have the fund has not been released yet. And but the difficulty on my part is that the person concerned who has been made a respondent, he is no longer there. The deputy commissioner interviewing.
How you are filing a contempt? See the order? See the order? Page 11. The aforesaid dispute which have been raised in the instant petition is fairly covered by the judgment of the full bench in Kamsarali, wherein a direction has been made to make chronological list of similarly situated petitioners and thereafter to make payment as and when the funds are available on pro rata basis. With a similar directions there. Now you have been admitted. Now they have put it you in a chronological. Whenever the funds is in here, they will get it matter over. Okay.
My only,
You have to show when you get an order of this type, you have to show that there is somebody else who is below have been granted. This is in violation of cancellation. Where's your no case?
so my lord, what that I'll produce before you, lord.
What?
That below me that they have already received the payment. But I am not receiving, lordship. Since 2013, lordship, this bill is pending before the authority 2013. 2013, they are saying that there is no bill, no bill, no bill. Lord. This is my humble submission. 2013, lordship.
Obviously, when you filed the writ petition in 2017,
Yeah, no.
then
But
where
we
will
are-
they find anything?
But we are approaching, na? Several times we approach. But while we have failed, then only we have approached this honorable High Court. The amount is a very small amount, lordship.
देखो, Art Mr. So-and-so, the learned counsel appearing on behalf of the learned counsel appearing on behalf of the instant contempt proceedings have been filed alleging willful and deliberate violation to the order dated 28/11/2022 passed in deputation number 5168 of 2017. It is the case of the from a perusal of the order dated 28/11/2022. It is seen that the learned court and bench of the court had directed the respondent authorities to consider the case of the petitioner in terms with the direction so passed by the full court in the case of Kamser Ali versus State of Assam, reported in 2008 4 GL 1. This court have duly taken note of the judgment of the full bench in the case of Kamser Ali, wherein there is a direction as to what is required to be done by the respondent authorities. That is, the respondent authorities are first to verify as to whether the contractor in question is entitled to the said amount, and thereupon to put the same in a chronological list. And on the basis of funds being available, the payment has to be made. In a chronological manner. So the learned counsel appearing on behalf of the petitioner submitted that the said directions so passed in Kamser Ali Supra have not been complied with. Inasmuch as although it is a clear-cut admission on the part of the respondent authorities that the petitioner is entitled to an amount of 4,36,000, but merely on the basis of funds not being available, the petitioner dues have not been paid. The learned counsel further submitted that there are other contractors whose bills were submitted subsequently, but their amounts have been cleared. In that, accordingly, this court therefore directs the learned counsel appearing on behalf of the respondent number 1 as to whether to place on record the chronological list so prepared after due verification and what is the present position of the petitioner in the said chronological list. List this matter again on 8th of September 2025.
But in the meantime, the petitioner has to bring the new incumbent because the respondent for whom I am appearing is no longer the present incumbent has to be included here. This is the concept.
This court directs which department?
Deputy Commissioner.
The district commissioner?
No.
Nagaon. and Mr. Dinath, who appears, who is also the senior government advocate, shall place before the.
Item 9 and 10.
What is this?
Please, Your Lordship.
Contempt case?
My lord.
So
My-
big,
My lord, speaking order, I have received a speaking. Dada,
speaking order passed.
my,
Tell what to me.
I have not received the statement.
Huh?
I have not received.
Miss, your name
and thus
appearing on behalf of
PWP, the chief engineer,
Contempt judgment.
item number, who is the respondent?
chief engineer,
Yeah, I think respondent has a number.
Chandon, commissioner and secretary.
Respondent number,
One,
all the
Mm.
respondents.
Right.
In both the contempt petition, submit that after due verification, a speaking order has been passed on 5th of August 2025, whereby the claims of the petitioner have been rejected on the ground of submission of fake, of the fabricated, of the tempered documents and misrepresentation of facts. First, a copy of the said speaking order dated 5/8/2025 is kept on record and marked with the letter X. Ms. So-and-so has also furnished a copy of the said speaking order to Mr. N. Alam, the learned counsel who represents the petitioners in both the contempt petitions. So taking into account the above, the taking into account the directions so passed by this court in deputy number 830 of 2022 and deputy number 87 of 2022 have been substantially complied with. Accordingly, this court drops the contempt proceedings. Be that as it may, this court, however, observes that the dropping of the instant of both the contempt proceedings shall not prejudice the petitioner to assail the speaking order dated 5/8/2025 before the appropriate forum. Not here.
I filed it by affidavit, my lord, against their speaking order. That was for.
Not here. Whatever it is said, it is fake. Now, therefore, you have to challenge it somewhere. You tomorrow find it that appropriate forum will be this court.
Item 11.
Perhaps be instructors, the private respondent be discharged from service pursuant on 26/6/2025, pursuant to an order of this honorable court, judgment and order dated 19/6/25, passed in another writ petition questioning the appointment of the private respondent.
What has happened?
He has been discharged from service, my lord.
Who?
The private respondent, pursuant to an order of this honorable court, passed in another writ petition questioning his appointment as beyond.
What order did they pass?
A fresh selection process has been directed to be initiated by this honorable.
Oh. So it is covered
Covered.
and he is no longer in service. That is your given. And there was a direction also to hold the fresh selection.
Yes.
So you are be happy. You are still right.
Yes. Scheduled right.
The people
As they are.
as they
Some.
went to appears on behalf of the petitioner and Ms. Asher, the learned standing counsel of the Guwahati High Court, appears on behalf of the respondent number one. Legally, Ms. B. Chaudhary appears on behalf of the legal aid counsel, appears on behalf of the respondent number five. This court duly takes note of that the issue which have been raised in the instant petition no longer survives in view of a judgment pronounced by this court on 19/6/2025 in deputation number 4004 of the 2024, whereby the selection of the respondent number 5 was set aside. Ms. Esther, as chairman, the learned counsel further standing counsel further submitted that in pursuant to the judgment passed by this court on 19/6/2025, the Chief Judicial Magistrate Bolaga had also discharged the respondent number 5 from service. So taking into account the above, nothing further remains in the instant petition, and accordingly the petition stands closed. The
Item 12.
instruction to place the order dated 6/5/2025, by which the respondent number 5 was discharged from his service, his or her, or his service, is kept on recorded after the letter X.
Okay.
Yes.
This case, my lord, earlier occasion, my lord, Mr. Bora took time to produce the record, my regarding settlement.
Mr. Bora, you not only appear for the Guwahati Municipal Corporation, you have taken the whole of all municipal corporations.
No, not. Board has given me a.
I see.
Board has
You don't leave anything for the other private, other lawyer. Yes.
board. The Paradise comment, Paradise comments are disturbing.
Okay.
The board has decided to give it to the petitioner. But since the letter came from the respondent number 2, it was endeavored over to that respondent number.
Now what is happening? Nothing remains.
The stay order is there.
Stay order
is there.
We make a, because it,
Because I quoted 10 lakhs
Ah.
and the award is given to a person who has quoted 5 lakhs.
so now the board wants to give it to him.
Board wants to give it to the petitioner.
Ah.
The letter came from the respondent number 2. Ultimately, it was given to the respondent number.
Respondent number 2, executive member.
Who is respondent number?
Executive member, Urban Development Department, ETC.
Now you want to give it to
Petitioner is the highest bidder. Was selected by the board. Ultimately, it was later handed to respondent number 7. Order was passed for the respondent number 7.
That is later you will find at page 37. And the comparative statement is 36.
and who is appearing for respondent number 7? What is your case?
But I am.
Huh?
Sorry, my time. I have put in the red link, my lord, that particular portion.
This is for no good reason. What do you have to say? You can't defend. You must have said this. Respondent number 2 must have seen the comparative statement upside down. Maybe, my lord. Eh? Heard Mr. Kutuki, the Learned Counsel, appearing on behalf of Mr. Mr. Esbora appears on behalf of the respondent number 1, 2, 3, and 2 also. Oh, my lord. Part of the PTC, my lord. 2, 3, and 6. And 6. I MCT appears for respondent number 4 and 5. And Mr. So-and-so appears for respondent number 7. The present writ petition has been filed by the petitioner being aggrieved by the action on the part of the respondent number 3 in awarding the cattle market under Basugaon Municipal Board for the year 2025-26 in favor of the respondent number 7, in spite of the fact that the petitioner was the highest bidder. This court duly takes note of that the respondent number 3 had issued a notice inviting tender for the period 2025-26 for settlement of the cattle market under the Basugaon Municipal Board, dated 7/3/2025, and the settlement period was from 1/4/2025 to 1/3/2000. What is 1/3? What is it? Where is that? Where is the notice in the to 31/3/2026. The petitioner, along with various other bidders, participated in the said tender process. The bid quoted by the petitioner was rupees 12 lakhs. No. Your name is Tonde.
No, Pitom ne.
What is your name?
Padma Kolta. Number 1.
Was rupees 12 lakhs 51,000. However, the bid quoted by the respondent number 7 was rupees 5,30,355. The tender evaluating committee had, after making of the respondent number 3 board, selected by majority the petitioner for the financial year 2025-26 as the lessee of the cattle market. However, the respondent number 2, who otherwise did not have any authority, insisted upon the respondent number 3 to award the contract to the cattle of the cattle market toward the cattle market to the respondent number 7 at an amount of rupees 5,30,355. Being aggrieved, the petitioner has approached this court by filing the present petition. This court, by an order dated 4/4/2025, state the settlement order dated 28/3/2025 in favor of the respondent number 7. The interim order thereupon have been continued. The record reveals that no affidavit was filed. The record further reveals that in spite of opportunity being granted, no affidavit has been filed. Today, Mr. Espora, appearing on behalf of the respondent number, have placed before this court a para-wise comments issued by the chairman of the respondent number 3. The said para-wise comments are kept on record and marked with the letter X. From a perusal of the said para-wise comment, it is mentioned that though the petitioner is the highest bidder, but because of the fact that the respondent number 2, who is a superior authority of the respondent number 3, have issued a communication directing the respondent number 3 to allow the tender of cattle market in favor of the respondent number 7. The impugned settlement order was made in favor of the respondent number 7. It is the opinion of this court that such actions on the part of the respondent authorities to issue the settlement order of the order dated 28/3/2000. What is the order dated 28/3/2025 in favor of the respondent number 7 is a clear case of violation of Article 14, inasmuch as the same is not only a case of unreasonableness, arbitrariness, but also is a case which is a clear abuse of which suffers from mala fide in law. Accordingly, the impugned settlement order dated 28/3/2025 is set aside and quashed. It is required to be interfered with. This court therefore disposes of the instant petition. Are you willing to run at the same? Yes. Because 3 months have gone. Yeah. Proportionately, they will reduce, I suppose. Have to do it. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. The impugned settlement order dated 28/3/2025 in favor of the respondent number 7 for the settlement of the cattle market under the Basugaon Municipal Code for the year 2025-26 is set aside and quashed. Number 2, the respondent authorities, more particularly the respondent number 3, is directed to proceed for settlement of the cattle market on the basis of the comparative chart statement. Comparative statement, comparative justification report, and allot the said market to the most, to the market in terms with, in accordance with law. First, this, huh? Direction be issued for
Earnest money.
the counsel appearing on behalf of the respondent number 7, number 3, good, huh? Submits that he had submitted the earnest money and appropriate direction be issued by this court that the respondent authority should return the said earnest money. It is the opinion of this court that if the respondent number 7 wishes to seek refund of the earnest money, appropriate application may be filed before the concerned respondent authorities, and the concerned respondent authority shall duly consider the same in within the parameters of law.
Supplementary item 16.
What is this?
May pejorative, may pejorative. Sometimes maybe he can the petitioner is newly engaged.
Or 16?
Yes, sir. Service is completed. Responding, the respond.
I have got a 7, 6, 8, 9 Malad has completed as per laws in my court. Order.
You have filed a additional affidavit. No, additional affidavit because last time you sought for time to bring on record. What is the interim order?
The federation list of the which was not prepared, but I kept in MS.
So everything is done. So we now fix it for admission. Taking into account that the pleadings are complete, list the matter on 11th of September 2025 for admission. Interim order passed to continue.
Time being item 1.
Why does this judgment is relevant? Is the reason why. Earlier judgments, Saurabh Bhagat, Saurabh Yadav, are not on page of rule. This is a judgment. Kindly come to para 30, para 20. Para 20. Rajesh Daria. David, kindly come to paragraph number 5.
Yes.
Rajesh
Rule
Daria.
9(3). Yes.
See rule 9(3). Got it? Yes, yes. Everybody of you read it.
Rule 9(3) of the Rajasthan Judicial Service Rules 1955, rules for short, which is relevant, reads as follows. Reservation for women candidates shall be 20% category wise in direct recruitment. In the event of non-availability of eligible and suitable women candidates in a particular year, the vacancies so reserved for them shall be filled in accordance with the normal procedure, and such vacancies shall not be carried forward to the subsequent year. And the reservation treated as horizontal reservation, that is, the reservation of women, shall be adjusted proportionally in the respective category to which the woman candidate belongs.
The last line, similar to what it said, the third line. But what happens is like this, as I could have said, see, what is social reservation? It is given under the second is it's a special reservation. The other is the social reservation given in court trade system and 54 trade. Now, what is required is first you have to mark it up. How are they? In Daria's case, therefore say, if there are 30 people of exit, you cannot make it. Or with the advertisement that it's 21 and 9. We cannot. It could be 30. Out of 30 posts, 9 are there. The company advertised. But without benchmark, can be done, but it normally exists.
Ideal scenario.
Ideal. Now, what happens is like this. In a list of 100, 51 is general, others are the reserve. In 51, if it is 70, has to be open. There are already 70. But you have to pick it up. Or not 51. You have to take up here of your with reservation. It has to be something like 100 or 100. You have to have. Then, if you are having the reservation, the horizontal reservation, and the 17 then problem because there's 17. If it is 16, the 52 may not be a general. See, therefore, there is a touch, there is a flash, or yeah, or in because
interviewing of the
interplay between vertical and horizontal. And because of the fact that this woman gets it, when she is taken as a meritorious candidate, whatever may fall below, maybe OBC or whatever it be, she taken if it was a general also she would have taken, but it is OBC, MOBC, whatever she will be taken up. And that would be construed to be like a vertical of reservation. And therefore, the 51, which is the person concerned, if he's a maid, he would be brought, he will be removed. And this 52 or whoever 52 or 56, where the woman is, she goes there. And thereby by that, it becomes like a vertical reservation out there because you have to have 17, irrespective of where you are. Thereafter, if you see the OBC is vacant, so you have to get another OBC from somewhere. Fill up again among them. That is somebody, yes. That seems to be what I could do. And you get this answer more particularly in Daria's judgment, they have referred to the judgment of Anil Kumar Gupta. It gives a more clarity. If you see paragraph 18, Daria paragraph 7. Huh?
Anil Kumar.
No, it is there in Daria paragraph 7. Have a look at paragraph 7 in Daria.
A special provision for the woman made under Article 15(3) in respect of employment is special reservation as contrasted from the social reservation under Article 16(4). The method of implementing special reservation, which is horizontal reservation, cutting across vertical reservation, was explained in this court by this court in Anil Kumar Gupta versus State of UP. The proper and correct course is to first fill up the open competition 50% on the basis of merit. Then fill up each of the social reservation quota, that is SC, STA, and BC. The third step would be to find how many candidates belonging to special reservation has been selected on the above page. If the quota fixed for horizontal reservation is already satisfied, in case it is overall horizontal reservation, no further question arises. But if it is not satisfied, the requisite number of special reservation candidates shall have to be taken and adjusted, accommodated against the respective social reservation by deleting the corresponding number of candidates therefrom. If, however, it is the case of compartmentalized horizontal reservation, then
this is compartmentalized means where you are saying SC 2 post. Or here, general, if we are going for 51-17 post. Out of 51-17, this is compartmentalized. Then, if it is in the advertisement, it is compartmentalized. Then you can do this. And
in such a case, the reservation of 15% in favor of special categories overall may be satisfied or may not be satisfied. If I respectfully submit subject to again correction. If I read again, this was judgment I was about to here.
This is Nilima not properly.
That, but still it remains Nilima the vacancy based post, and that is a Lordship here. What is it saying? That first, which I am also saying in the first, the open category quotas will be filled. Then fill up each of the social reservation quotas. That is SC, ST, BC, whatever. The third step is to find out how many candidates belonging to special reservation has been selected on the above page. There is no quarrel of that.
I will say, among the 100 posts, hey, rule kong check. You have the rule, na? You see the schedule to the rule.
Yes, it's given 151.
Among 100, it is given. So let's take the example of the rule itself. You fill up all as what you are going without forgetting about special business.
Women, I forget.
But that is why in Saurabh Bhagat say, Yadav say that you have to have more because there might be more insertion if they do. So in Saurabh Bhagat, he therefore say that although it is 100, they have to have more than what is required. Step with you.
Yes, for 69 paragraph.
So therefore, you have this entire thing done. But then, if it's a horizontal reservation, now by virtue of vertical reservation, in view of the special reservation, the woman gets an upper hand.
The question is that whether it is 101 or 51. That is where.
No. It's not
If
51.
I take if the list is taken,
No,
the
this is
select
what
list-
it is.
it is.
And the answer is therefore is that paragraph number 23 of this judgment.
Of
That
Dangi.
Sadhana.
Sadhana Dangi.
And in fact, why you get the answer, you see, what happened in the High Court. Finally, see paragraph 6. What the High Court held. What you are submitting is what the High Court held.
Yeah.
See paragraph 6.
In sum and substance, according to High Court, going by the settled principles of law, migration of reserve category candidate on the basis of merit for allotment of a seat in general category would certainly be applicable to vertical reservation. However, the same principle would not get attracted in horizontal compartmentalized reservation. By virtue of Rule 3 of the 1997 rule, the same principle as applicable to vertical or reservation would not be applicable to horizontal reservation. If an OBC female had competed against a reserve category, she would not be eligible to be placed in the merit list of unreserved category at the stage of application of the horizontal reservation. Even if an OBC female candidate has secured first rank in the overall merit list, being a candidate of the reserved category, that is to say OBC female, she would not be allocated or earmarked as a seat in the general unreserved female. Finally, the High Court held that the candidate not falling in unreserved category could not be brought from any of the list of the OBC female, ST female, ST female in order to accommodate the horizontal quota meant for unreserved.
Now, I think the
Paragraph
20.
Again, what I understood, what the High Court had said is that once the woman has become an OBC woman becomes top. Now, when she becomes a OBC woman in an unreserved category at the top, she loses everything else. She becomes a topper, and she is, as in our case, STP loses it. Now, when the authorities will look into it, then they will see, they will look as woman only. Now, whether she was OBC or not, that is not to be counted. This is not my case.
No, kindly come to 6.4. 6.4.
If an OBC female had competed against a reserve category, she would not be eligible to be placed in the merit list for unreserved category at the stage of application of
Horizontal. This is what the High Court held.
Yeah.
This is what you are asking. You therefore say that this person concerned who is number 8, that lady who is
Sumana
there,
Paul.
who is otherwise also going to get it.
Yeah.
She is already there.
Yes.
So she cannot be put up there.
That
is your contention.
Yes, yes.
And if she's not there, if she's not,
Then I get.
You don't get it. Because the OBC will come in for filling up that OBC post.
No, if she does not, if she stays where she is, then I get it.
Therefore, you say that she can. Mr. Mohanta's submission is this: that the person who is number 8, maybe she is an OBC, but by virtue of horizontal reservation, she will go up, and she will be number 4.
So here,
and therefore, the person who is number 14 below you, but an OBC, will take the piece of this
yes.
number 8.
No, at this stage, the horizontal and the vertical mixes up. That's where the
This
point
is what has been stated out here in paragraph 20.
but again, in Daria's judgment, when
This is after considering all Daria and all.
No.
You kindly see paragraph 23, 24.
23 is clearly said. The law laid down in Saurav Yadav is very clear that even while applying horizontal reservation, the merit must give precedence and if the candidate who belong to SC, ST, and OBC have secured higher marks are more meritorious, they must be considered against the seat meant for unreserved candidate. The observation made by the High Court in the instant case is, in our view, do not lay the correct law. The High Court failed to appreciate the conceptually that there will be no distinction between vertical and horizontal reservation when it comes to the basic idea that even the candidates belonging to the reserve category can as well stake a claim to seats in unreserved categories if the merit position entitles them to do it. Now, this is there. This is a three bench just saying a clear line. Now, if Lordship comes to Daria again, where it is saying that the reservation, horizontal and vertical reservation are different.
No, this, you see, Mr. Das, we have to understand. When a three judges bench is explained by another three judges bench, the explanation given by the three judges bench is binding upon me. You may ask this matter first, get it dismissed in the division bench, go to the Supreme Court, which will again be laid before a two judges bench or three judges bench. Thereafter, you have to ask the Supreme Court to refer it to a five judges bench, and the five judges can help you out. I can't.
Lordship, there, I mean, the line said in Daria, where it's clear the line said that the aforesaid principle applicable to vertical reservation, principle regarding RK, so on these things.
You see, these judgments clearly, therefore makes it very clear. And therefore, I brought you 6.4. So what the High Court held.
High Court.
You are asking me to follow what the High Court held.
High Court.
And which the High Court has been set aside by a division bench, by the Supreme Court.
Lordship, then the explanation to the proviso of 4, section 4, the act which says
Yes, please.
we read again 4.
Whether that 30% reservation of vacancy in respect to voters for the remaining unreserved category of years shall be available to the reserved category.
Now, this law, whether it was this law, since it is considered whether this judgment will be binding in view of the fact that this law is there and whether this explanation has been taken.
No, my lord, that your lordship kindly see that your lordship kindly see provided further that 30% of reservation of vacancies in respect of the women in remaining unreserved category of the candidates shall be available to women unreserved category only. Unreserved category means it is open, my lord. It is open, my lord. Unreserved category means. Your lordship kindly see where 14 of the my lord, that the judgment of my lord Tangi, my lord, where 14, my lord. 14.
The decision of this court in Saurav Yadav had considered all the cases on the point starting from Indra Swane to Mamta Vist as well as other decisions. It was finally concluded that the candidates belonging to the category of OBC female or any other reserved category female were entitled as a matter of right to have their candidature considered against the category meant for unreserved female candidates if their merit position demanded so. It was further held that the category of unreserved female is not specially allocated or reserved for candidates who did not belong to any of the categories of SC, ST, or OBC, and that by very nature, unreserved category must mean and include every person who, on the strength of merit, could be entitled to be considered in that category.
So, another aspect of the matter, when the advertisement does not say in it, the advertisement does not say, only says that women's reservation would be applicable, meaning thereby it is not compartmentalized. Then the reservation of the woman, which is a special reservation, uses the status of having reserve, unreserved, everything. So all becomes in the status of an unreserved. Because unless you comply with, you see, therefore the thing is, the normal requirement therefore is that you have to state in your advertisement who is the person, how many posts you are reserving for each. Normally. If you don't do it, this is the problem you are going to face. It becomes very difficult to work out the rule or that. Because what is being said, if you see the rule, it's very important.
Rule only,
three.
my lord. Rule 6.
Direct recruitment of APSC or selection committee by filling up the vacancy by direct recruitment on the basis of recommendation of so as the case may be, the following procedure while making a request to the APSC for recommending candidates for director, the appointing authority shall also furnish the information about reservation in favor of candidates belonging to the woman. The APSC area, as the case may be, shall furnish its recommendation about such number of women candidates in order of preference for appointment. The appointing authority shall make the appointment of women candidates on 30% basis, as have been shown in the schedule to the rule. So how it is to be done?
Competent.
So this is to be done. Done by the appointing authority. In the case of non-availability of adequate number of candidates belonging to women for the appointment, the post will be picked up by the respective reserved, unreserved male candidate to which the post is meant. The appointing authority shall consider the list in accordance with the procedures of the respective service and shall also consult the APSC where such approve the list. Seniority of the candidate to appointed shall be in order of preference shown in the combined list furnished by the APSC or by the selection committee.
Lordship, if I may just interrupt. If Lordship had said about the Nilima judgment, and Lordship, if we read again 4, is it just thing, if we read, it says in case of non-availability of adequate number of candidates belonging to women for the appointment, the post should be filled up by the respective reserved, unreserved male candidates. So it becomes vacancy post. Because if
No, therefore I was saying it is exactly like same like 9.3.
9. Yes.
Daria's case 9.3 says that.
Yeah. But again, in the concurring judgment of Saurav Yadav, it says it can be carried over.
No.
Right.
That could be.
Yes, government. What
59.4.
Yes, government.
59.4.
Government is a party.
Yes, government is a party.
Because government is an interpretation there too. Government is not there.
Government is a party. When is
Yes.
the cannot carry forward?
No. It as per rules or carry forward. 59.4. If the vacancies cannot be filled by specific categories are to be carried forward. Also 59.4 it says if the vacancies cannot be filled by the specific categories due to the shortfall of candidates, the vacancies are to be carried forward or dealt with appropriately by rules.
Paragraph?
Paragraph
It is for
59.4.
vertical. It is not for the
59 point.
that is
No. Vertical.
vertical.
This is the conquering.
This is a concurrent.
Where?
No, Lordship.
This is for verticalism.
Wait.
The vacancies cannot be filled up by the specified category due to shortfall in here. The vacancy are to be
Page 60.
This is for vertical. On top it is written, the
Yes,
features of
vertical.
vertical reservations are.
60 days.
Then 60 says, horizon
right.
on the other hand by its nature are not inviolate full or carved in stone. They are premised on the overlap and are interlocking reservation. So therefore I was saying that the moment it touches, earlier there is no problem. When you have 17 out of 50, 51, no problem. But the moment the 16, you have 16,
Then the problem starts.
then the OBC or anybody who is the 52, because you have to therefore, you see, you have to draw up the post as 100. The 51 may be on merit, you may put an ST or STP, but you have to draw it up on merit. That anybody who was there, that you can, he's an ST.
Woman, as per this,
So
the woman has to come, that is it. But the rule, the proviso again says in a different way.
they are premised on their overlap and are interlocking reservation. As a sequel, they are calculated concurrent and also with the inviolate vertical or social reservation quota by application of the various steps laid out with clarity in paragraph 21.3 of Lalit Day's judgment. They cannot be carried forward.
Then again, then that judgment, it becomes vacancy post only in my understanding. If it cannot carry forward, that means in that advertisement, if there was no woman, assuming for a moment there was no woman, no one, not a single woman applied. If it happens, it can happen, that's not a big. Then there was no suitable candidate. Then it cannot be carried forward. Even though if there was a 9-woman kind of, because it says, rule 4 says that it has to be given to the next male. Rule 4 says that our rules, because here it is again saying as per the rules. So our rule clearly says, so it's vacancy based only. So that judgment Nilima Das,
Vacancy based.
so would be a correct judgment. In my respect, I'm not saying in my respectful understanding.
They cannot be carried forward. First rule that applied in horizontal quotas one of adjustment, that is examining whether any of the horizontal categories are adjusted in the merit list, in the given category, and then in the quota for such horizontal category. Or if we just take the simple example, let us forget anything else. In direct judgment, they have made it. There are 30 posts of SC. 9 are required,
To fulfill women.
of which 8 are there. But 27 is the next woman. The 10 goes up and the 27 comes to upper line. This is the man. So how you do it is there. Now let us see in the facts. You see the facts up here.
Facts is 11.
No, that gradation list over this. Finally come to this one. Yeah, page 41. Next.
So Sumona is 9.
Now 1 to 4.
It is done. Liton is number 4.
No, 1 to 4 is a general case.
Lordship, Lordship, one thing is now sure that Liton Dev has to go.
Liton Dev is going.
He is going. That is now who is replacing Liton Dev? That is the question.
No, Liton Dev has to be replaced by number 9.
As per the judgment, but my submission is that the rules are there. As per the rules, I should be.
In monopole place, my lord, that is OBC quota. Then
Because
OBC
that
will
will be a
be
quota.
Yes.
Because this person goes out there on
getting
merit.
high mark. But monopole getting
Because she is being considered as a meritorious.
As per the judgment, I'm not even quarreling on the thing that it is clear. Everything is clear.
Merit.
Right. But my submission is regarding the rule. And one more submission, which I know Lordship will discard it. Here, I was a OBC also. I was a OBC, and now I'm Rubina. If it has to be looked at every aspect of it. Now, since Rubina is not here, I've given my OBC certificate out, OBC. Then, if I had given the OBC certificate, I would have got it. I did not give because I got married. I thought that I've given statement in my affidavit also that I thought that after marriage my caste is gone. I mean, I cannot take advantage. Whatever be, that's a different thing.
You
That's
married? How do you get the OBC certificate?
because I am an OBC.
Born.
Born.
And married.
Married to no, general.
But you don't have a OBC.
I have annexed also.
You didn't get it.
I did not apply as a OBC. That's the difficult. That's happened. That's I'm just saying. Otherwise, too, I would have got it only.
Yes.
I would have got it. I have given in my affidavit. I've given in my affidavit in reply also.
Why don't we do one thing? Can we do one thing? We don't have to go. Has to go.
My lord, you don't have
We move to monopole up.
then that.
As regards the OBC, let it be decided by them again. Have a fresh selection.
Verify my certificate.
No, fresh selection.
Fresh selection.
Verification.
Oh, fresh selection, yes.
That I can't do it.
Yes.
It did not apply that. That is legally.
Lordship is saying a fresh selection.
Based in aspect of your decision.
Then it will be only.
Can I say that monopole selected that it was wrong? She should have gone there. The selection of it is also wrong.
We had to remove because only three men, three is four men.
Therefore,
At any cost, it has to be melody cast. This list has to be recast, but in what manner? So for the
recasting them and directing them to pick up the.
Then it would be OBC female only. Now, if when the advertisement would be there, so if there is a re-examination, then it has to be OBC female only. Because in this quota, if this post was already there, that this post was supposed to be filled. It's a vacancy based. This was for some wrong.
Not carry forward. It is making submission. Doesn't carry forward. You're making the submission.
Then the whole select list has to go.
Why should it go? At best, it can go only for return date. It can only go for return date.
Yes, return date too has to go. There is no.
Go. But for return date, monopole comes in.
So
now, if the monopole comes in, therefore the only remains is the
OBC comment.
Yeah.
OBC
So
will
this.
depend.
OBC.
Yes.
Not
No, that three posts, one will go to a woman.
so then it is OBC.
That's what I said.
Now there is three posts. How many? Who is to keep that there?
No, male.
Male.
That is a confusion.
Actually, earlier also we has to keep the
19 is the petitioner.
You are 20, 19 or 20?
19, I'm 19.
20.
20 is Pompey Sharma, she is general. She will, and
you want a Ruby Nath will get.
Now Ruby Nath, as per them, the Ruby Nath comes in place of Sumona Paul.
But they have made that submission in their affidavit.
yes.
Ruby Nath get.
Yes, they have made.
Then I can't touch. Now what you say, how do I take care of that food?
As I understand, my lord, that it is for unreasonable. Your lordship.
But if reservation of meaning let us see
one
first
thing.
why did the reservation provided should be
My lord.
provided further. 30% reservation of the
Respect of women
respect of the women
for a remaining unreserved category. The candidates shall be available to women understand. For women unreserved category.
Okay, if this has the intent, again, being from the petitioner side, I'll try to find out. But if this intent has to be looked, if this proviso has been provided, this is the third proviso, not the first or second proviso. There is a second proviso. The second proviso. It says, provided 30% reservation of vacancy in respect of women for the remaining unreserved category of candidates shall be available to the women of unreserved category only. Now, what are the remaining, when the remaining is there, this remaining comes at below. What is above? It is provided that the aforesaid reservation shall be inclusive of the reservation provided statutorily or otherwise of the scheduled caste, scheduled tribes, scheduled hills and other things. So when the first means in my respectful submission, the proviso first says that whatever is there in the reservation, it happens. Thereafter, this woman part will come. All the judgments are to the fact that the meritorious person should get it. There is no dispute to that fact.
Open category is not a quota, my lord. So open category is open to all, my lord. It is on as per merit, my lord.
Yes, that open will be starting from where? That is the question that has to be in my respectful
but don't you think this second proviso goes contrary to the horizontal concept, both the fact or with the vertical reservation? Why I'm saying the ethical interest of
that is very
a person, irrespective of whether it's enjoyed reservation or no social. If he is merited, then he goes up. If he goes up, he should be taken as an unreserved category. If he has to be just is that unreserved category. Then how do you conceptualize a proviso whereby you still keep 30% or the unreserved post? Because by virtue of when there is an interlock,
yes,
by virtue of a person who is an SC or ST, if meritorious can go up.
yes, that right from several Indasani, my lord, it is yes.
They
merit
will
always
therefore go up. Once they go up, then how do you maintain this particular ratio or keeping 30% for unreserved category intact for horizontally?
What Chini is saying that it is unreserved means it includes everything. So
my question is, how do you keep the unreserved category of 30% intact when there is an interlocking permissible under vertical and horizontal reservation?
And Lordship, the proviso.
Just for example, a ST can very well become a person who can be promoted, appointed to the post of among the posts reserved for unreserved
General category.
general category. So therefore, he can very well eat up on account of a merit. The SC or ST can eat up a general category post. If that be so, how do you keep the 30% intact? No, here for unreserved intact. You see this rule, the second rule proviso, conceptualizes that you keep the 30% intact for unreserved.
And
how do you keep it?
And
is
if
it
it is
possible to do it?
no unreserved. Yes, my lord. Here, my lord, comment can clarify here. Then unreserved. Whether it is here unreserved mean, my lord, general. Here, my lord, your lordship kindly see fill up by unreserved.
Here, Yeah, in my respectful submission, if this is not general, then the word could have been used women of any category. Women of any
Can
category.
be available to the woman of
Any category.
Unreserved mean any.
Why is the word unreserved used then?
no. Therefore,
That is that means
therefore
it is
that is
general
the
category.
problem.
That's where the
You
problem
see, therefore, wouldn't if we accept what Mr. Das is saying, that is the meaning, which also prima facie appears from a reading of. Isn't this rule, the proviso, contrary to the interest one is just,
Yes.
so I'm saying, how do you keep it intact? Yes, Mr. Das. You are an expert.
No,
Not you.
not you, not
You, I will ask you after some time. Now we are still amongst the high. You see, Indra's one is says that a person with SC or ST being merited can eat up a post which is kept reserved for a general category. If merited, it's vertical, it is possible. If it is possible, how do you keep the 30% reservation amongst or women reservation intact, which is a horizontal reservation intact, when there is a vertical reservation possible to do so, and there is always a possible for interlocking. Here the rules say for direct recruitment, you have to have 30% reservation for post. No problem. It says this 30% shall include all reservations, SC, ST, whatever may be, all these reservations. But it further says that those 30% which is reserved for, further, the 30% reservation of vacancies in respect of women for the remaining unreserved category. I don't understand the word remaining why they have not used the word reserved, unreserved, but remaining. The word used is remaining. Remaining meaning they are keeping it intact.
No, remaining means what I, my your lordship kindly see, my lord, your lordship go to the rules, my lord. Remaining means, my lord, first your lordship kindly see it, there is 100 posts. So STP 10, SC 7, SC 5, OBC, OMBC 27. Thereafter remaining.
Then do I get it?
There is the remaining, my lord, 50 woman.
Then do I get it?
That reserve in that, my lord, remaining.
No. There's no quarrel with 50. No, why I'm saying the problem which is arises is this SC, ST, they are by way of interest money is allowed to eat up the post which is there for general category.
And by this proviso, generally is eating up.
What you first need to go ahead is to first make the list of all vertical reservation.
Yes.
Thereby a person with ST or SC but meritorious can be put in item number 1, 3, 4. So 1 to 51, if we go by the 100 point, 1 to 51, 4 or 6 OBC or whatever may be, they can very well come amongst the meritorious. If that be so, how do you eat up? How do you keep the remaining? How do you use the word? Where do you bring the word remaining?
What do you mean by remaining here? Yes.
How do you bring the word remaining? Remaining means you are first adjusting the SC/ST amongst their quota. And then you are doing it for general. You see, that is completely contrary to what Induswani is saying.
Yes. Also, Zadav also.
All these other judgments say. But herein, therefore, I'm saying it is not in respect to a rule. Saurabh Yadav is not a case with the rule, without a rule. That is
Clearly
what
said in 23.
Huh?
Clearly in 23, it only said
22, paragraph 22,
clearly
clearly
states
say
about
it in there, not in rule. But how to take care of this, the word remaining? Meaning thereby the rules, there has to be a reading down of these rules if you are to bring it within the purview of, or if you, or it is seen that the rule, because this rule appears to be contrary to Indus 1.
Yes. That means if your lordship follow this rule, then it has to fill up by only general candidate. That
No,
open
not only
category.
that. See, as per these two judgments, 2, 3 judgments, whatever may be, first Indus 1 categorically say, all these SC, if they are merited, they can
They'll
very
go-
well go and become a part of the general category.
General.
However, if we apply this rule, which is a rule pertaining to horizontal reservation, 30% which is there, you can't touch.
30%.
30% reservation for women, which is there for reservation, meaning thereby, just for example, let's go to the state of, or in Karbi Anglong we are having. You may have a lot of more SCs, STs. They are scheduled tribe areas. You have 90% person who are on merit, taking care of 99% who is taking care of 51 posts. On merits, they get
all general is filled by quota.
quota. Then how do you take care? Means if we read this proviso, it has to be only unreserved. Then this 30% cannot be filled up. Because this is only reserved for what he is submitting is this 30% of unreserved category can never be filled up by any reserved category. That is his
Yes.
submission as per rule.
Yes.
Now, therefore, let us take the example in Karbi Anglong. You have 100% filled up on merit and eating up the entire general category. If you for your
It's open.
Open category, unreserved category.
I understand there is no problem with Soravia. The,
Problem is
the,
proviso.
the formulation which is done in Soravia or Satna Singh is absolutely clear. There's no quarrel with that. But the problem lies with the rule. That is why I'm saying. How do you take care of rules? Section 4.
Provide.
So therefore you say the first proviso, yes, I think it may be a possible explanation. The first proviso say that you earmark first the SCS for the purpose of 30%. The second proviso say that the remaining unreserved, that is the 51, shall be available to the women of unreserved category only, meaning it is not open. How, therefore, the problem which is I am having is this. This section, not rule.
The section.
Ah.
It's a section.
Never read it. This is the problem which I am.
In respect of women for remaining unreserved category, it can be available to the unreserved category. This content takes identification, if my understanding is correct. Yeah. What I to say in the law, but it provided that the aforesaid reservation shall be inclusive of reservation provided statutorily or otherwise of the scheduled caste, scheduled type, hills, other backward class, or of the backward persons with disabilities within the respective reserved category. This means whatever the reservation was there, by virtue of this proviso, may not inclusive. That means it is in interest.
Or you can very well say section 4 of this act conceives of only compartmentalization of the
Because it contemplates apartment can be available to the women unreserved category only. That means the UR can be filled up. UR can be filled up only by UR.
That's where the whole.
but if that election is not held under section 4, yeah, but it's going on. Here it does not appear there. That means you have to categorically mention your that you are having a compartment that against this post for women or three post of
OBC 1 for
you have to mention it. Now, if you don't mention it, how do you then do
Column. What? Yes. Another column. But even then,
if it is not there, right, right now.
Because the advertisement talks about the government.
Remember that other matter with the there also you did not do so. Because at the later point of time it was taken. We have to go over the how do you do it? Because you want to do as per the act. You are but the act keep up.
The line of Daria. Daria.
I understand. Mr. Das, I understand.
it's UR only.
But you are taking note of. It's a case without rules.
Which is clarified in 22 of Tangi.
When it is without rules, you can do, but with these rules, how do you do it? That is absolutely the Supreme Court is practicing moral. Now, how do you take care of this rule when this rule remains like this?
And when the rule is there, the judgment will not.
That is overridden. How do you treat it? That is the problem we are facing. Otherwise, so I also know you will say, you know, your expert opinion we are seeking because of that.
Era 14 or 10,
Yes.
clear.
Patna.
Yes.
Nangi. Sadhana Singh Nangi.
Or we can even a very, I think it's last line, that order, that one can very well say, once a person gets benefit of it as merit, as merit, he takes the color, he or she takes the color, but unreasonable.
It's a human. If male declared as a human. It's a human. So,
I may not like, but
may not.
Otherwise, the other
Inhuman. It becomes a person, just a person without attributes. It's a person.
Therefore, the moment a person
Vice.
has merit, irrespective of anything,
My lord,
he becomes
unreasonable. So that
I think
probably, my lord,
this
that point also meaning that, my lord.
Earlier, what was the thing? Was not available.
Withdraw horizon.
All of that. Opening the technical.
I
But-
think
Anil Gupta.
the carry
Yes. Anil Gupta,
the way
that
carry, but it's the visualizing. They
Yes.
have study.
Here. Take down dog. Go down below. Vertical. It is equal.
Not only men or everybody who has merit
Yes,
is
exactly.
I think this phrase may be that everybody here therefore who is the undeserved aspect mentioned in this profile. cheating or interlocking. This section 4 with interest. Otherwise, it becomes very difficult. What is being done is you are first finding out if we read otherwise, you are first doing it with HCST, all this thing. Then you are going to the unwritten. Now, if we say that HCST, they will remain, that 30% there will be there. Remain. And anybody who has married is another.
Exactly. So the moment we say in the rule, women of Amrita not conceive only to women general. We cannot conceive that. Yes. That's my understanding.
In other words, anybody who has married,
Married, that will be my lord.
and that is the, and if that interpretation is given, now let us read again the provision. Provided further that 30% of reservation of vacancies in respect of the woman or the remaining unreserved instead of anybody having married shall be available to those having married only.
Yes.
So if we read this unreserved as person having married,
then my lord, problem will be solved.
yes, what do you have to say? Well, it
Here I had made the expectation,
all
all the select list was made private respondent, which Litondas is also there.
But his job is going. He cannot. No. But it is otherwise mandatory panel. Litondas cannot bring it. Litondas or whatever may be. Liton Dale. That's putting back the amount of. Litondas putting back the.
Yes. Opening basement होता है.
Bangladesh creator.
Yeah, but that with
Liton Dale.
I think it's you are very many cases don't do that. They're also you're here for now what happens? So they take it as monopole you are appearing. Be careful. I'm not noticing this time, but be careful. In that stenographer matter, you were appearing for those persons who were grateful for greatly also. Were you not appearing? You can't. Final word. Don't fear because the one day because there is an absolute conflict. The stenographer grade 2 had a right to get it on the basis of SETI Commission's recommendation. So and they were meritorious. They were there. And their very interest is being harmed by stenographer grade 3, for whom again you are appearing. Isn't that he appeared for? Except he didn't appear for number 17 because he didn't get his instructions. Sometimes because don't appear because this time also you are doing it. You are appearing for Sumona Paul also.
Yeah.
Sumona Paul is now going to go take the place of Litonde.
Then he also paying for Liton. Yes, he is also paying for Liton.
Huh?
He's paying for Liton. That's it. Lordship is saying.
So Sumona
The conflict.
conflict in interest.
Should I put a note of the in the order next time? Huh? Deprecating your practice. This is a good question. If that paragraph 14 out here makes
yes. Paragraph 14.
anybody without practice, anybody without merit
Yes.
is a so your submission is only to that, and my answer is next time stop it. It's SG Borua. Your matter I couldn't take it. We'll take it some other day. Anyways, today I was a bit not here.
My lordship, can it be taken another day, the date can fix, my lordship?
Yes,
Can
when
it
do
be on
we fix it?
21, my
Hmm? 21, okay.
lord, and
We'll get the record.
my lord, on 21 also at, my lordship, today it was at 21 also at
He's coming for admission or hearing?
hearing. My lordship has already heard on land one day,
Huh?
or one day, my lordship has heard it on land. That's-
I remember your case. Here he was a case, I tell you exactly what happened. A person concerned, he was some working as some dealing assistant or whatever may be there. He was the person who was looking after all the files of the execution proceeding. The judgment debtor moved this court and got a stay. The stay got vacated and this court passed an order to proceed with the execution. On the basis that order was placed before that court, the court issued a writ for delivery of possession. Thereupon, in the meantime, they filed an application. This was going on, and it was fixed the date for report of the Nazir. In the meantime, the judgment debtor moved an application. And when this application was moved, there was a stay being granted. But in the meantime, this stay out there was no mention about any case number. And thereafter, this particular person concerned, later on it was found out that when there was a stay, this person did not point out, and the judicial officer, nothing happened to him, and it is this tiny fly who is being taken into account by these people. Nothing else.
There was a mention of the case number in the order itself. I'll pay. My case number was mentioned in the order.
That is
Last occasion.
your case. I've heard you there.
Yes.
I've asked him to produce the case. So facts are